Hello, welcome. This is Pete Calabrese. I'm CEO of CanAm Investor Services. We are the wholly owned broker-dealer affiliate of CanAm Enterprises, one of the largest and certainly most successful regional centers in the history of the EB-5 program. I am very pleased, I'd say honored, to have joining me today Mr. Joey Barnett, the partner from Wolfsdorf, and as well as Mr. Charlie Oppenheim, the director of visas at Wolfsdorf, as well as, dare I say it, the czar of visa allocation. We're very pleased because there's always good and huge important topics to be bringing up in the EB-5 program, but I think the Visa Bulletin is one of the ones that is most pertinent. And there was a bit of news this past week that came out that I couldn't think of anyone better to discuss with than these fine gentlemen. So Joey, Charlie, thank you so much for joining us, and I appreciate you guys coming on.
Thank you, Pete, for having us. It's an honor for us to join with you guys, and CanAm Enterprises, as you mentioned, is certainly one of the gold standards in EB-5, and you guys have a long history. We've had a lot of mutual clients, and it's our pleasure to be here and to talk about the January 2025 Visa Bulletin. And we do a chatting with Charlie on a monthly basis. Charlie used to write the Visa Bulletin for the Department of State for over 2 decades. And so he's got a lot of experience, a lot of insight, and honestly, some I guess skills and able to interpret what's in the coming months and how to really best give guidance to our potential EB-5 investors on how to best move forward and ensure that you can get your green card in a timely manner. So I always love speaking with Charlie, and I invite you guys to check out our Chatting with Charlie. We post them all on our YouTube channel. You can look back and also register for future events. And Charlie, maybe you can give us just a little bit of background about yourself. I don't think everyone knows exactly, your full history, but maybe you could talk about, what you've done in the past and why you're such a valuable resource for us today.
Sure. I worked for the U.S. Department of State for a little over 43 years. The last 23 years of service, I was the Chief of Immigrant Visa Control and Reporting Division. And in that, the primary responsibility was making the determination of the final action dates, which governed whether people could be interviewed or file for adjustment of status, resulting in either the issuance of a visa or a green card. The decisions I made during my time allowed over 9 million applicants to either be issued a visa or receive their green card. I also would consult with the White House and congressional offices when they were thinking about immigration reform issues. And in that regard, I testified before Congress on 2 occasions. And as Joey mentioned, I was responsible for publishing the monthly Visa Bulletin, which the dates in the Visa Bulletin indicate who is eligible for final action on their case in the upcoming month or current. And also that bulletin provides other visa-related information to keep the industry informed of what will happen. And when I was writing the Visa Bulletin, I always tried to give it at least 1 to 2 months advance notice if anything strange might be happening in the future, so that people could take that into consideration for their future planning.
That's great. That's great because, every month the Department of State releases this Visa Bulletin, and that is really what allows somebody to get, at least in the EB-5 context, their conditional green card. Once the conditional green card is obtained, then the Visa Bulletin doesn't really matter for that investor. But up until that point, this is what everybody is looking at, in particular for China mainland-born investors and Indian-born investors. And maybe what I want to do is take a step back and just, Charlie, maybe you can kind of just walk us through what the Immigration and Nationality Act says about the different visa availability in a fiscal year, because that gets to this footnote E that Pete brought up, that is in the January 2025 Visa Bulletin, and sort of the impetus for us having this conversation today is that, um, they're pretty much saying that there's enough demand in the EB-5 space already to create these visa backlogs for China, India, and potentially rest of world, just based on the pending data. And so, your insights here will really help guide the industry. And so anything you can do to help sort of clarify what they mean from that statement and how that's going to be impacting availability and the concurrent adjustment opportunity in the next couple of months, that would be very helpful.
Yeah,
Absolutely.
it's very important to remember that these dates, when they're listed, this being the dates which will apply for January processing, that this indicates which visa categories are available based on the applicant's priority date during the month of January. And it's important when an applicant's case is ready for final action date, it is not this chart, but the chart that is listed for their month, whether it be 6 months, a year down the road, it is the chart A date then, which governs whether they will be able to receive their immigrant visa or not. These dates, when you see a date, for example, China first preference has a November 8th, 2022 date. That means visas are only available for Chinese applicants who have a priority date earlier than November 8th of 2022. And the final action dates, which are listed here, are established by the State Department to prevent number use throughout the year from exceeding the annual limit for fiscal 2022. So they already know that in China first, there is sufficient demand, and they may move this first preference date forward during the course of the year to allow maximize number use under China first preference limit. If you notice, for the 3 set-aside categories, the rural, high unemployment, and infrastructure, they're all Cs. That means the category is current. There are more than enough numbers for all applicants who have an approved petition and are ready for final action during the month of January. And so these dates may change in the future. I do not expect these dates to change anytime in the foreseeable future, because a final action date should only be imposed when number use year to date plus anticipated demand for the remainder of the year will exceed that annual limit. And right now, there is no indication that number use during fiscal 2025 will exceed any of these 3 limits. Therefore, there would be no reason for them to establish a date. And if that were to happen, I don't foresee it before summer, if at all.
Okay, there's a lot of good information there, and I just want to take a moment to kind of break it down piece by piece. So, first of all, your priority date for EB-5 is the date that you file your EB-5 petition, the I-526E. To make that petition filing, you need to have made your investment into a new commercial enterprise. So the investment comes first, then the I-526E filing comes afterward, showing you've made that at-risk investment. And because there is the current listing in the set-aside categories today, anybody who is in the United States and is eligible to file the adjustment of status can submit that 485 at the same time that you file your EB-5 case. That is this unique opportunity that doesn't exist, at least for China and for Indian nationals and any other employment-based category at this time. And so even though we know there will be backlogs in the future, there is still these interim benefits that you get to file the adjustment, to file your employment authorization document application and to file for advanced parole, these are interim benefits that you get during the time in which your EB-5 case is pending. And even if there is subsequent backlogs and visa retrogression, you still are able to remain in the United States because you've timely filed your adjustment of status, and you're able to get extensions on your EAD and your advanced parole because your adjustment remains pending even when there is that retrogression or visa backlog. So the opportunity that is available today has not changed because of this January Visa Bulletin note. And as Charlie mentioned, it's unlikely that we're going to see a final action date or an application filing date in fiscal year 2025, which ends, or at least through the summer of 2025 is what Charlie had just mentioned, right? Is that
Yeah, and
accurate?
I think that summer would be a worst case scenario. I really believe, based on what we're seeing now, that it would be unrealistic that they would require the imposition of final action dates this fiscal year. They definitely will be required in fiscal 2026 when there should be enough approved petitions and processing, but not this fiscal year.
And so that you say approved petitions, and that to me is such an important part of this, is that the demand for these visa numbers from the Department of State's point of view really can only come in once USCIS has approved enough I-526E petitions. But what I believe this note is saying is that, look, the USCIS is actually getting to that point now that actually we may have to start imposing these final action dates at some point in the future. But when I'm looking at the data that USCIS has provided, and I know it's old at this point, we only really have data through the end of June on I-526E adjudications. All I see from there is that they've adjudicated less than 800 I-526Es post RIA. So that is not enough demand to meet these large supplies that we have, at least in the rural category, and to some extent the high unemployment category too. And so that I think is a really important aspect, is that this is a warning shot from the Department of State saying we see what is in USCIS's filing system right now, and we are giving people warning. Am I reading that right, Charlie?
Yes, again, this is just to let people know that this is on the horizon. It is not imminent, because as you say, Joey, there's several hundred approved petitions, yet there's over 4,000 numbers available in the rural category. So for State Department to impose a final action date, they would need to know that there will be more than 4,341 estimated numbers used this year. And if they've only got 500 approved petitions right now, there's no way that's going to happen. So therefore, there's absolutely, based on the data we have available at this point, in fiscal 2025, there's absolutely no reason to impose final action dates. And also, with the application filing date, if anybody is nervous because they saw that application filing date notice, it's important to remember that typically the USCIS requires the use of Chart A for the filing of adjustment of status applications, typically in March and beyond. They're allowing the Chart B dates to be used for January filings, but that's likely to change either in February or March. So even if they were to at some point later in the fiscal year, which I think would be summer at most, to impose Chart B application filing dates, Chart A would still govern your filing, and Chart A is going to say current. So you're in excellent shape But it's, as Joey mentioned, it's very important to act in a timely manner and file as quickly as you are able to do so to take advantage of this unique opportunity this fiscal year.
Pete, can we go back just to the Visa Bulletin chart with all of the employment-based categories? I think it was like that 2 slides back. Oh, yeah, this one right here. So the reason why we're kind of talking about this unique opportunity is because for many folks, in particular Chinese and Indians who are in the US who are stuck in these visa backlogs, EB-5 is really the only route that they have to a green card. And every day I am having calls from people inside the United States. They're on H-1B, but their priority date is 2017 or afterwards. Maybe they have children who are going to be aging out and won't be able to get the green card based on the EB-2, or maybe they're worried about all of the layoffs that are happening in the tech industry and they want a backup plan in case something happens, or they're just tired of waiting and seeing the slow advancement of the final action date in the EB-2 and EB-3 category. And they're thinking, what am I doing here? You know, like they want to advance their lives. They want to get out of the, continuous visa stamping and extensions and everything like that. And they're looking for other solutions. And based on today's immigration law, it's either get married to a US citizen or do EB-5. I mean, that's really it. And so, yeah, you do EB-5, you get your spot in line. There is going to be a backlog, but that's okay. So what? You get to remain here. If there are layoffs, well, you're going to have your EAD in 6 to 8 months. You can work wherever you want, and that's good for 5 years. And you can extend that indefinitely in the event that there are further backlogs in the future that don't allow you to get your conditional green card. So it's sort of like there is significant opportunity costs of doing EB-5. I'm sure, Pete, you talk about this with potential investors all the day, all the time. I'm sure, you have people that you and your team are, they want a better future for their families, right? And
Absolutely.
they're stuck based on
Yeah.
what we have today. And this is why so many people are looking at EB-5. I mean, I would say the majority of my clients these days are coming from within the United States, not
Mhm.
outside of the United States, and that they're doing it as a backup plan. And now I'm telling them to, stay with your H-1B employer as long as you can, right? That gives you the most amount of options. But hey, you see what's happening in the industry, and people want some stability, they
Yeah.
want some security. And I think because of this current Visa Bulletin, this gives them that unique opportunity. What the January note is saying is that it's not going to be around forever. And so take
Mhm.
advantage while you can.
Yeah, no, absolutely. And Joey, you said it perfectly. I mean, we have this conversation all the time because this is a tremendous amount of money. And it's certainly one of the largest investments that many of these people will make, but it's without a doubt the most personal investment that any of these people will ever make. And so the description that we're always having is letting people and just reminding people that the 99.9% of the investments that you'll do over the course of your life will be, with a monetary rate of return outcome that you're pursuing. But this is a very unique investment opportunity where you have a very valuable outcome, tremendously valuable, because the opportunities that come with having a green card are just huge compared to any other visa that they might be on. But that very valuable outcome does not necessarily come with a huge monetary rate of return. So you're right. When people will look at this, especially people for whom this is a significant amount of their net worth, this is a huge decision that they make. So we're always talking about that and making sure that they are understanding that this is a great opportunity that doesn't come without having some real ramifications, maybe to their cash flow, to their but it's a very important one, and for the long term, especially for the stability of themselves, be able to stay here, stay with their families, is a really tremendous one. And I think that And first off, the explanation that you guys give of the Visa Bulletin is so tremendous. And for any of you people who are listening just for this side and don't listen to chatting with Charlie, with Joey and Charlie, that is a lot of the backdrop that you would get from that. So thank you guys for going through that, and especially for talking through the ramifications of footnote E. I'd say a question that I would potentially have, or I could see someone asking, is, now that we've gotten this, quote unquote warning shot that there are significant interest coming in, would there be another different type of warning? Would they expect to see this footnote just remain on the Visa Bulletin, or would it potentially come in a different form in future bulletins, or would the next outcome that people would see on the Visa Bulletin potentially being a date of final action for these set-asides?
Yeah, if I could I'll answer that, but I real quick point to that both of you all have alluded to. If you notice on both China and India in the second and third preference category, those dates are only going to be advancing a couple weeks per month on average. And so it's going to be a long time. So if somebody has the means to apply for the fifth preference, they would have 2 shots at a visa. And even when final action dates are imposed in the set-aside categories, those dates are likely to be much more favorable and reached quicker than somebody that's currently sitting in the second or third preference line. In terms of your question about the notice in the bulletin, they may allow it to stay for another month, maybe for February, in case anybody were to miss it for January. But my guess is they will probably remove it and not put it in again until they see that it's actually going to happen within a month or so. And again, the fact that they did it early, I see this strictly as a warning shot to prepare people for the future so they're not caught off guard. But I really don't see any, based on their processing at this point, any need to impose either. Because also with an application filing date, typically those are established where you have X amount of applicants competing for numbers, and you need to generate, in order to reach the limit, say that you have 2,000 applicants right already, and the limit is 5,000. Well, you set an application date which will allow 3,000 more applicants to file, so you can use all 5,000 numbers for the year. There's no need for that right now. They continue to need people to file based on the final action and the application date. So again, I think this is purely to prepare them for the future going into fiscal 26, but it is not a major concern for 2025 unless the State Department and or USCIS were to have a major change in the amount of cases that are being approved and resulting in final action.
Sure, that's going to be comforting. So, and also, I guess, so to that point, then if they look up in a month or two and this footnote is now no longer present on the Visa Bulletin, it doesn't necessarily mean that the demand has gone away. It just means that they've given that preemptive warning, and they've given that notice that this is something that people who are considering this should be aware of. Now, I guess then, though, to that point as well, if they do see another notice of this sort that comes up, say, in the middle of the year, or getting towards the middle of the calendar year, getting towards the end of, say, the fiscal year, that's the point where they should really start to be taking this as a little bit more of a real point of urgency. Yes,
and again, once USCIS announces that Chart A will be used, the fact that they later in the year impose a final or an application date will have no impact based on their current policy. But they are likely, I believe the application filing dates will be listed much earlier than any final action dates will be listed in the Visa Bulletin, and that will be to control future filings for during fiscal 2026. But they may go ahead and establish those dates so that the State Department would stop sending out notices to start assembling documentation, because the State Department doesn't want people to be assembling and submitting any time-sensitive documentation that they don't think would be processed in fiscal 2026. So state may, they use the application filing dates. Once they're established, they continue to use them regardless of what Chart A says. So again, the Chart A would be to govern the remainder of fiscal 2025 for those processing overseas in regards to submission of documentation.
Can I just make one more comment, Pete, because you made a really good point about the return from EB-5 is not always monetary. It's the ability to live in the United States for the rest of your life, and same with your children, and sponsor other family members and become U.S. citizens and things like that. But obviously 800K is a lot of money. And one of the things that I get asked about a lot is, well, when can we get the money back? And is that based on priority dates and when you have your conditional green card? And that's one of the things that actually Congress changed in the EB-5 Reform and Integrity Act, is that now your ability to get your money back, that sustainment requirement, is not tied to when you get your conditional green card, meaning it's not based on visa availability. So you could, there are two parallel requirements. Your money must be at risk and used for job creation, and then you can get your money back even before your I-526 hypothetically is even approved, right? I mean, that's what USCIS's question and answer says online. So you could go through the EB-5 process and get your money back and sort of still be in that visa backlog. It's not like you have to go through the entire green card process in order for you to get your money back. That's one of the big changes in EB-5. And actually, I think the money doesn't have to be at risk for as long as it used to. And that's a huge, reason people don't want to be away from their money for extended periods of time. If you can get the immigration benefit and get the money back in a sooner period, hey, that's gravy.
Yeah, yes, absolutely. And you bring up a great point. And really, it kind of leads me to the next thing that I would say to you guys is that now that we have this and we have this information, and we can look at this and say, okay, this is something that's helping us to make a practical decision with some realistic timelines that we're looking at here. And we can start to plan ahead accordingly. So with that knowledge that that this is not, because this footnote is coming out, does not mean that there is a data file action that's coming right away, but that's not what this is indicating. It's just giving a little bit of forewarning. And as Joey had said, there is a change in the sustainment period that allows for a more realistic time frame for when your funds can be returned back to you. So with all of these things, as people are taking into factors, what should an investor do now? Joey, you have these conversations all the time. I know I do as well. And we want to make sure that people are able to make good, strong, rational decisions. What would you tell someone who is just starting the process now, or someone who has been looking at this for a while and has been kind of wondering whether or not this is the right time to go? What would you suggest to someone who is now doing that sort of due diligence?
All right, so for those who have been in the EB-5 due diligence process for some time, my comment would be, if not now, when? Get your spot in line, make the investment. There are ways to, look, there's still some time before the end of the year. And I'm having conversations every day about people who are concerned about capital gains, and things like that. Are they disposing of assets now in the next couple of weeks and then doing more next year for some tax savings? There are lots of decisions that can be made right now that can save you money. Obviously, that's depending on your personal circumstances, but there is no reason to delay. For those who are just getting into EB-5, I would say you got to start working with an attorney to make sure that your source of funds is ready to go. That's a very important part of it. We have to document how you earn the money that you are now investing into the EB-5 project. But really, the more I think time uh, dependent issue is finding that right project. And I have to give CanAm a huge round of applause for that white paper that you guys put out with JTC. I think that is an incredible
Thank you.
resource. And it is, I'm pointing everybody to that. It is a 5 to 10 minute read about EB-5 project due diligence. It is by far the best resource out there. It is incredibly worthwhile. And anyone who's looking into EB-5 and wants to understand what are the considerations when looking at EB-5 projects, how do I make sure that I'm picking something that is safe from an immigration and from an investment point of view, you guys should be looking at this document. It's absolutely great. CanAm did a great job of getting great writers, and myself included, to put that white paper together. But truly, it is a really great resource, and I'm happy you guys did that. It's a great thing for the entire industry. So thank you. But either way, the time is now.
Yeah.
Get your spot in line, start talking with Pete about CanAm's projects and what's coming up on the market, and start really organizing your source of funds so that when you finally made that investment decision, you and your immigration attorney can quickly transfer the funds, quickly file your case, and get your spot in that priority date line.
I think that's great advice, because you can't force something that's not there, that's not ready. But this is a time frame where, as people who have been looking, especially people who have been looking for a long time, there are great professionals that are out there. Joey, there's your firm does a tremendous job and can work through things and can try to get people going as quickly as possible. But there is only so much time. And so don't wait until, say, we get to that second footnote that we alluded to as potentially being the call to urgency, to now pick up the phone and call an attorney and say, hey, I need that my source of funds done. Can you be done in 2 weeks? Because that's, just like the State Department is giving you a reasonable expectation or some reasonable timelines to help you to prepare for your decision making. You need to make sure that you are doing that on your own as well. And look, there is the potential for, it is lawful, say, if you are looking at an investment and you say, oh, I can start, I'm ready, I've been talking with my attorney for a while, the execution of it might take a little bit of time, and that maybe I could begin funding my investment, half of the investment now, and then fund the second half of it in 3 months. Well, that's something that you can talk about with your attorney in terms of structuring that correctly. And you can talk about that with your regional center as well. So say, like for us, for instance, we do allow for it to the point that we can with the groups that we're working with. So we're a third-party regional center. So our ability to offer that sort of flexibility really comes down to the specs of the borrower that we're working with and their draw schedule, all those types of factors. But when possible, we certainly want to try to accommodate investors in doing that and allowing for filing while in the process of investing, so that you can get that spot in line ahead of time. And I anticipate there will be a good number of people that are looking to do that as we get into the new year, especially with this guidance that's going forward. But even something like that, don't think that that's something that you can wait to the very end and start to move forward with it and just assume that you'll be able to start with a certain dollar amount and go forward. Ask these types of questions of your attorney, whether or not it's feasible, and of your regional center that you're talking with, to make sure that they can offer that to you as well. But all of these things are saying, if you have the ability, now is the time to be starting to move forward and really starting to have these conversations, because these things can take longer than you expect. And Joey, I'm sure you've had as many conversations as I have that people say, I'm totally ready. I am totally ready. I just need to hire an attorney, find a regional center, liquidate my stocks, sell this property back home. Totally ready.
Right, right.
Yeah, so start taking these steps ahead of time so that you can be prepared for what could be coming, a little bit ways down the line.
Yeah, I would say this too, your 2025 resolution, get going on EB-5, right? People work on their resolutions in the first couple of months. This warning shot from the Department of State is a perfect time for your resolution to be due EB-5. And look, things are going to be changing next month when the new administration comes in. You know, President Biden and USCIS, they're now requiring medical exams to be filed with the adjustment. That wasn't required a month ago. Right. And so now everyone who was looking to file last week is scheduling their medicals. Like there's going to be things like that that are going to come out and that we're going to have to work through with your immigration attorney. And you need to be able to be flexible with that. But right now is a good time to speak with someone about source of funds, start strategizing which sources are best documented, which are best, most productive from a financial point of view to use. That's something that you guys can start working on now. And like I said, if not now, when, right?
Yeah, absolutely.
Yeah.
Well, it's great. I mean, Joey, that was supremely helpful. Charlie, this was fantastic. I mean, any other parting words of advice for an investor who's now listening to this? They've now gotten a little bit more comfort in terms of the timing, but anything that you could potentially pass along to them to help them in their pathway forward.
Just to reiterate what you both said, you need to act in a timely manner if you're considering an EB-5 investment. You always want to be as close to any line, the front of any line which develops in the future. We know that lines are going to develop, so you want to act in a very timely manner now to get your spot so you can be as close to the front as possible.
Absolutely. And you got to focus on working with a good regional center like CanAm. I can't say that enough. Your source of funds will help you get the conditional green card, but the permanent green card is based on the project that you select and the job creation that it creates. And so your full immigration benefit is based not on your source of funds, not on your immigration attorney, but on your regional center project. And that's why it's so important to talk with experienced, reputable regional centers that have a track record of going through this entire EB-5 process, creating the jobs, repaying the money back to the investors when they're able to. That to me, I think is the big key, and it's actually more important than the immigration attorney that you work with.
I keep it the biggest hurdle that people have is making sure they have a sort of documentation. Thank you so much for the kind words, and we feel the same. You guys do a tremendous job, and making sure that your source of funds is documented in an appropriate way is one of the key steps, and we talk about it all the time. Well, I mean, with that, guys, this was honestly a real pleasure for me. I've watched your piece, chatting with Charlie every month. It's tremendous knowledge. So to be able to talk through this with you guys is very important and very highly topical matter for a lot of the people that are listening. It's just a real pleasure for me, and we really appreciate your time. Thank you guys
Thank you so much, Pete. Have a good Merry Christmas and Happy Holidays.
Soon. Happy holidays to you guys, and we'll talk to you soon.
All right.
Take
Looking
care.
forward to seeing you next month. Bye.